morning. This is our 5th or 6th morning event in Ireland, I believe, in terms of the arbitration forum, and the 31st or 32nd overall of these events, which have proved to be very popular, very well attended. Apart from this morning. I won't keep you long. Just a quick word about our next two events. On the 11th of July in Engineers Ireland, we have a workshop on the arbitration of small consumer disputes. And 2 days later, then Doug Jones, the former president of the CIR, talks at an arbitration forum at the OAI on the topic of adjudication. So this morning we're delighted to have David Dodd from the Bar Council as chairman of our event, and 2 excellent speakers and well-known speakers. He'll be strange to none of us here, Bill Holohan and John Tackaberry QC. So with that, I'll hand you across to your chair, Mr. David Dodd.
Thanks so much, Jerry. I'll be very brief. I got a call from Justin Johnson this morning. His agent wanted to know, looking for somewhere to hide out, where Tower in the corner. He suggested that he might come to this morning's event. Of course, we're very proud to him, but every seat will be full, and there's no chance of attending this morning. We don't like last-minute requests for attendances from superstars. My role really is just to introduce the 2 speakers. They'll both be well known, I think, to everybody in the room in any event. I'm going to hand you over to Bill now. As you know, Bill is well known in insolvency, bankruptcy, and also ADR. He was the ADR Lawyer of the Year in 2013, which is certainly a well-deserved award. He's a senior partner in Holohan Law. He's well known also not only in practice but also for his varied writing and teaching. So without further ado, I'll hand you over to Bill for the first half of today's presentation. We'll have about 15 or 20 minutes, I think, with each speaker, and then we'll have questions and answers, and we'll have an opportunity to have a coffee at the end of the minutes with our colleagues.
When Aaron first contacted me and asked me would I give a talk, of course I thought, definitely the grey hairs are giving an impression of some kind of wisdom which is to be shared, until I realised that the morning that's in it, the 22nd, is the same morning that Aaron, as it happens, is going to be in the High Court on behalf of a party to an arbitration, seeking to defend an arbitration award that I gave. Where Aaron is for the claimant trying to enforce it, and there's a cross-motion, stroke application under Article 34 of the Model Law to set aside my award on the basis that I was obviously biased and unfair in the award. So I think it was probably just a pure coincidence that I happened to leap to Aaron's mind on that morning when he was considering what to do on the 22nd of June. Because the thought had occurred to me, was it the Shea Healy song for the Eurovision, Why Me? So for what it's worth, here are some ramblings from my head. And I started off wondering, what am I actually going to say about what to charge as an ADR neutral, to use the term that Aaron coined, i.e. as an arbitrator or a mediator or whatever. And it reminded me of the joke about one doctor who telephoned a second doctor inquiring about a third doctor friend of theirs. And he said, I hear you operated on John. What did he have? Oh, 4,000 euros. No, what did he have? He only had 4,000 euros. And it's really kind of encapsulates the succinct answer to the question. The short version of this talk is, it depends. The slightly longer version is, it can be complicated. And when I started looking at what would the Chartereed Institute say about this, I found, lo and behold, they actually have a guideline on how to go about charging. And for those of you who are unaware of it, there is a practice guideline number 3, guidelines for arbitrators as to how to formulate their terms of remuneration. Curiously enough, there is no such guidance given to mediators. But if you actually read it, I think the principles follow through. And it says, the remuneration of arbitrators depends in each case on the law governing the arbitration, the agreed arbitration rules, if any, governing the arbitration, the ethical and professional rules which govern the arbitrator, depending on what profession, architects, quantity surveyors, accountants, solicitors, barristers, and drawn, and basically says it should be agreed, which is a very helpful guidance. It then goes on to say that it's essential that the arbitrator would agree on these beforehand. Basically, because if you don't, you've got a major problem afterwards trying to work out exactly what the basis of remuneration was. And this is where I'm interested to hear what John has to say afterwards. On the mediation front, the IMI, the Mediators Institute of Ireland Code of Conduct, has a guidance in relation to fees, and it says if fees are payable, which presupposes the possibility that you might be charging at all, and that you're doing something that has a sense of public duty or pro bono. But it says you must clearly explain to the client if you're asking forward the parties, or the parties if you are the actual mediator, the basis on which you intend to charge costs, fees, expenses, outlays, etc. And it says the fees charged may take account of the type of mediation, the complexity of the matter, the expertise of the mediator, the most crucial factor obviously, and the time required. And then it goes on to talk about how some mediators will charge on an hourly basis, some will do a half-day fee, some will do a full-day fee, with a kind of a rollover on the top. The essential question is, do you have a written agreement with somebody beforehand, or do you not? Or do you simply, as Bernard Goldie told me some time ago, he simply sends out, whether he's an arbitrator or a mediator, he sends out a statement of terms on which he intends to act. If you have an agreement, it's great that you have everybody signed up, because you then have the contractual position that you have a clear contract in writing stipulating the terms, the rates, the hourly rate, etc. But what happens if you only have one side signing up? Is there then a possibility of you being accused of being partial or biased towards the party who's actually signed up to pay fees, and possibly being biased against the party who hasn't? And curious enough, I have a situation at the moment where I'm contemplating suing the parties to an arbitration, where one party who didn't sign up to the agreement applied in the course of the arbitration to dismiss the claimant's claim for failure to adequately plead their case, which application one might think I had acceded to, given that following it I said I had an award ready, please pay me, and the party who requested that declared the award is now refusing to pay. So this is where I'm particularly interested in what Jonathan had to say afterwards. The alternative is that you set down in stone or in electronic form in writing, by email or whatever, the terms that you are prepared to operate on. And in the absence of protest and screams from the representatives of the parties, it is assumed that they have then adopted it and we can go after it. The important issue in relation to arbitrators, whatever about mediators, is that under Section 21(4) of the 2010 Act, once you say that you have an award ready, and here is my fees statement, the parties can ask you to make an order providing for the taxation of the costs of the arbitration. So as an arbitrator, again I had this in a situation where you get the feeling that somebody is going to have a row about your fees. Once you have the award ready, you send it out and you very quietly hope that they won't do anything for 21 days to allow you to get past the possibility of having to send your fees off to be taxed, scrutinised, criticised, and otherwise taken apart by the tax master or the county registrar, as the case may be. So, as a solicitor, we're required under the Solicitors Acts to send out a letter before client engagement, or as soon as practical, to use the words of the Solicitors Acts, stipulating the basis on which you want to charge. And again, in the time-honoured fashion of lawyers, you try to be as vague as possible to cover the essentials. And there are a number of things that are stipulated. One, the complexity, importance, difficulty, rarity, and urgency of the matters required. Two is where money or property is involved, the value. And that could be an important one. One has to wonder about the value. Aaron's leaping to the defence of my award this morning in the High Court, given that the award concerned is actually only €5,000. It was a silly car case. I'm quite sure the brief fee for counsel will probably exceed that when it was over. The importance of the matter to the client, where you're acting for the client, the skill, the labour or responsibility involved, in the extent to which any personalised or specialised knowledge is given or applied to the solicitor. So obviously for marketing purposes I would trade on the fact that as a result of what one of my colleagues called the triumph of marketing over substance, I managed to get the ADR of the Lawyer of the Year Award in 2013. And trying to convince people that they should apply a factor known as the L'Oreal factor because I'm worth it. The number and importance of the complexity of documents pursued or perused, that will vary depending obviously on whether you're an arbitrator, in which case you'll be presumed to have read the 17 lever act files that are delivered to you, or as a mediator where you can adopt the Joe Friday Dragnet approach of just give me the facts, man, just give me the facts. You get the headlines, I don't need to get bogged down in history. I explain to people when I'm a mediator, look, I can't change the past, and let's not get into matters historical too deeply, lest they become matters hysterical. We're more focused not on an adjudication of who was right or wrong in the past, but as a mediator, we're focusing on the future and formulating an agreed outcome for the future. The requirement of expert reports and opinions, time, place, and what circumstances the business, litigation, or any part thereof is transacted, and the time expended thereon. The most handsome fee I ever received, and the easiest one certainly I received, was many years ago. I got a phone call from a senior solicitor. This was now 25 years ago, and I had here and it was read. And I was asked, look, very short notice, could you step into the breach and act as an arbitrator? I've had a family bereavement in the UK. I'm the only standing relative. I have to go and do the needful in the UK in relation to this deceased, but the parties are all flying in from here, there, and everywhere, and they've agreed to have me find a deputy. There's a particularly area of law, is maritime law, in which I also have an interest and involvement. And my comment was, am I the 12th or the 13th phone call? And I was told I was only the 11th. But I was ready, willing. The question was I able? Now, the able question came into sharp focus when the parties walked in with solicitor, junior counsel, and senior counsel and told from each side, and they came up and introduced themselves, and they looked at me, and they said, by any chance, could we possibly have some time to have a chat about ourselves? I said, all the time we want. This was in the Burlington Hotel, as it then was. And I went downstairs, and over the course of the next couple of hours, the junior counsel was sent down to me to update me first of all, then the solicitor on the second visit. The third visit was the apprentice. And eventually, shortly before lunch, I was asked, could I come back up? They had settled and could I make an agreed award, which I clearly did. And then I said, gentlemen, this is the easiest fee that I've ever received. I have to invite you to lunch. So after the order has been given and we're getting into the opening social questions with Aussie strangers, one of the seniors said to me, do you do much of this kind of work? In other words, I've never heard of you before. You were suggested by the arbitrator who was bowing out. And I said, you mean that when you walked into the room, took a look at me and you said, oh my sweet God, he either knows sweet FA or he knows too bloody much, let's go out and say. Now, isn't that adding value to the process, allowing people to sort out the differences? The Chartereed Institute guidelines as well for arbitrators also can give some guidance on what you should include. And it says fees, cancellation charges, disbursements, VAT, interim payments, security for fees and disbursement arrangements in the case of settlement. In other words, if the parties, God forbid, are actually going to go off and settle and then offer you a choice of any two adjacent fingers on one hand, moving in an upwardly mobile direction when you ultimately to ask for your fees. Periodic adjustment of rates. On the Magnus Magnuson mastermind principle, I've started, so I finished. If you find yourself suddenly being told this is a 2-day arbitration, and on day 10 you begin to wonder, and it's beginning to escalate, and you had, in consideration of the fact that your tax bill coming up, decided to do a cheap and cheerful fee or something in order to get it in the door, and suddenly you find that you're now operating at a break-even level or even a loss level, can you adjust the rates upwards? So the factors in paragraph 2 and 3 of the guidelines are time and labour, the novelty and difficulty of the questions presented, the skill requisite to perform the arbitration properly, the preclusion of other employment, in other words, are you going to be cutting off your loans, and if you're going to be arbitrating as against an insurance company, being conscious of the fact that that means you're unlikely to be briefed by that insurance company either in the future or again if you have been previously, and if you have been previously you have to disclose that. Time limitations imposed, the expertise, reputation and ability of the arbitrator, and the undesirability of the arbitration. I'm really intrigued to know if anyone can enlighten me as to what the Chartereed Institute had in mind when they said you should consider the undesirability of it. So have I given you any great guidance? No. Some of the bigger, more famous mediators, arbitrators would probably charge a minimum of €5,000 a day. The average rate is probably about €3,000 a day. I've gone as low as 1,500 for a day when there was a quasi community element to it. I've even done pro bono ones. So it literally depends. But what to do when you have a refusal to pay the fees, where somebody is just refusing point blank? And before we get to the question an answer from John as to what he does and what whips, scourges or other implements he uses to encourage parties to pay up, I did a trawl and I found that there's a bit of a difference between the Americas and continental, or to be more precise, Britain when it comes to this. In the Supreme Court of Mississippi, they held that a refusal by a party to pay the filing fees to commence the arbitration despite a contractual obligation to do it, that was a breach of the arbitration agreement itself, and therefore the party had waived their right to insist on the arbitration, and it left it open to the other party to actually commence proceedings. That was in the case of Saunderson's Farms in 2003. Then the Alberta Court of Appeal in Canada followed on in 2008 in the case of Resin Systems Inc., and they described an application by a party who had refused to pay the filing fees on the initial fees under a scheme for arbitration when they wanted to commence proceedings, or sorry, rather, when they wanted to stay proceedings by the other party, when they refused to pay the initial fees for the arbitration. The court described the application for a stay as, quote, audacious, unquote, in the extreme. They held that the refusal to pay the fees was a breach of Article 11 of the New York Convention and Article 8 of the Model Law. But in the UK, last year, in the case of BDNS Limited, there was a refusal to pay a fee. When the refusal was by a party who wanted security from the other party, and they said, we will pay once the other side provides security for our costs in the arbitration. And the court said that that in itself wasn't a refusal to arbitrate, thereby depriving them of the right to proceed. It was a breach of the arbitration agreement to refuse to pay in accordance with the terms of the agreement, but it wasn't a repudiatory breach, in other words, they distinguished it. So, I'm going to finish on the point of where I am, and in at least one case contemplating suing to collect my fees, and I'm looking forward to hear what John has to say about his experience in actually suing and/or being paid.
Thanks so much, Bill. Would you like to take some questions now, or would you prefer to? We've heard a very obviously interesting talk from Bill. I'm not sure if anybody has any questions. John, you may have.
Well, I'm not going to have a lot to say, and I think it turns into a discussion quite quickly. But why don't I say what I'm going to say, such as it is, and then we'll see where we are.
Just follow me to a brief introduction to you, John.
Forget it.
I have a great quote here from Legal Chambers about you, which I was going to rely on, but I just at least read that out. It says you may remain unraffled when tackling difficult matters. We'll see how you handle the Q&A in due course.
And sort of supported by sugar. One of the reasons that Bill went first was because I couldn't actually think of anything to say that his topic wasn't going to cover. And having listened to him, I find myself in exactly the position when I suggested strongly that he should go first. Because I don't see a basic problem with suing for your fees, which is why I've done it. It's a straight, in the context of a common law system, such as we have here, it's a straight contractual situation. Either you do have a written contract with the parties, or you don't. Or you have a written contract with one party and not with the other. And all the usual rules apply. If you send out your terms in the good Bernard's way and rely on silence as confirming that they have agreed, you may find a court a little resistant to the idea. And incidentally, one of the things you have to ask yourself is whether you put into your terms of engagement when you send them out in the hope that they get signed an arbitration clause, so that you end up not in court but in front of an arbitrator. A nice question, and one well worth remembering. Can you rely on the only colleague within miles you can find who is not conflicted out of the job to do a reasonable piece of work when it comes to your fees? So far as actually getting the fees, what I certainly have done on 2 or 3 occasions is issue a writ. Once, a long time ago, in a maritime shipping arbitration in the City of London and Mayor's Court, and a couple of times in the Commercial Court. And you run into all the usual complaints. You will run into arguments about whether in fact there was an agreement, whether in fact you have calculated it correctly. I have had, I seem to remember somebody complaining bitterly that despite the fact that there was an express term in the agreed terms about travel time, they still didn't think they wanted to pay anything for travel time. It is as straightforward as that, but it is as difficult as that. If you haven't got signed terms, then you are in the difficulty that you are basically suing on a quantum merit. And that does leave the decision as to what your splendid and valuable services are worth in the eyes of somebody else to be decided. So in that sense, I don't see that there's a problem, which is one of the reasons why I think it's a matter of discussion. But having said that, can I add a few thoughts? And let me begin with one area where there is a real, there is a perceived problem. I don't myself believe that it's a real problem. One party picking up all the bill. Well, let's first of all take the point that if you were in a situation where you have a lien on the award, then it is almost certainly the case that one party will pick up all the bill, at least in the first place, and may or may not be able to recover the money from the other side in the light of what your award says. But that is not a problem. There is one English case which suggests that where you have a domestic arbitration and a single arbitrator on an ad hoc basis, not an institutional basis, in that situation, if one party pays all the fees, the court will remove the arbitrator for misconduct. I think that decision is a Court of Appeal decision. I think it's wrong. I have yet to find a book which says that it's right. Nobody thinks it's correct. It is obviously nonsense, because if that was the actual and correct rule, a reluctant defendant could derail any arbitration in sight by simply refusing to sign up or to pay their half of the deposit, and that has to be nonsense. But that wouldn't, in my view, affect your entitlement to those fees vis-a-vis the party that does sign them. And one of the reasons, one of the things that Bill mentioned was the taxing master crawling all over your claim. That's as between the parties. It's not necessarily relevant as between you and the parties, because your entitlement may be, hopefully will be, determined by your terms of engagement. What is permissibly recoverable under a taxation isn't necessarily the same thing at all. So you really do need to draw a clear distinction between the situation where the parties are arguing about what the losing party has to pay and what percentage of your fees are included in the costs for which they're liable, and your entitlement to recover against an individual party your agreed fees or your quantum merit fees. If you're in a quantum merit area, then inevitably everybody will look at any taxation that has taken place. But it's strictly irrelevant if you can justify what you have recovered, because the criteria which is being used for the two different exercises is a different criteria. And in international arbitration, certainly in my experience, for example, the ICC regularly expects the claimant to pick up the whole of the deposit when the respondent, as is almost guaranteed, A, complains about jurisdiction, and B, refuses to contribute a single dollar or cent to the deposit. And certainly, I have sat in a panel where, when we have been appointed, where this had happened, the very first thing that happened was that the claimant made an application for us to order the respondent to reimburse it its half, and we issued an interim award to that effect. But again, that is irrelevant to that was irrelevant to our fees, because in that case, our fees, as many institutional arbitrations, are determined by the institution. Now, in the context of fees determined by an institution, I know of nobody who has yet sued the institution in respect of the fees which they thought they were entitled to recover. There are a number of reasons for this, the first being that the institution will never appoint you again, And that is a good, practical, down-to-earth reason for going low-key. But the second reason is that, in common with the ICC, most institutions where they are administering the arbitration operate on an ad valorem basis. In other words, they determine the amount of the deposit by reference to the money that is at stake. And they determine, in their view, how much you as an arbitrator are entitled to. And you would have to extract from the great and good body the criteria that they had used and how they had applied those criteria and how they had divided the pie up. And it really would be a seriously difficult exercise. So you wouldn't want to be in that situation. So, if I may say so, on the one hand, an institutional arbitration, the question of suing, I think, doesn't arise. On the other hand, an ad hoc arbitration, i.e. one where the money is not controlled by the institution, then in that case, it becomes, as I say, simply a question of, did you have appropriate terms, and did they agree to them, or can they be regarded as having agreed to them? And if so, then you go home on your terms. If they haven't agreed to them, then you are seeking a quantum merit in an absolutely classic, old-fashioned way. Let me just, and incidentally, in looking round for authorities, it is not an exact comparison and should not be seen as an exact comparison, but there's quite a number of cases in the UK on adjudication and arbitrators' fees, and adjudicators' fees, and it's worth looking at the kind of principles which are spelt out there. But it should be a simpler situation in an arbitration because it should be more competently regulated by you when you got into it. The English Act is, of course, a great deal clearer on the subject of the arbitrator's entitlement than the Irish Act, because the English Act in section 28 spells it out and also deals with resignation and removal and all those other good things which can happen to you. And obviously, if you do resign, if your terms cover resignation and the appropriate grounds, which is probably unlikely, but if they do, then your terms will cover it. If they don't, then you may be in some difficulty as to whether you're entitled to resign, and if so, whether it's a breach of contract, and if so, how much money you can get. Equally, if you're removed, it may be that the argument will be that you have not provided the value that you undertook to provide. And so that's a situation in which one, I think, would be cautious about launching proceedings to recover money. Another situation, very rare, but it does occasionally happen, is where after you have been appointed, or the panel has been appointed, the parties jointly come to the conclusion that they don't like you and simply dump you and start with a new tribunal. Again, that's a situation where one might be cautious for simple PR reasons about commencing proceedings to recover money, because why did they dump you or why did they dump the panel? That's going to be plastered across the relevant news sources for arbitration if you start off proceedings. But that, again, isn't a legal issue. That's a pure human nature